Miss Gratian, don't forget we have to finish at 3:15.
I have not forgotten.
Good.
I have said previously I will finish by 2:30, and that is the target that I'm aiming for.
Good, thank you.
My lords, my lady, then, I was going to the judgment, the discussion and decision section at beginning at page 17 of the core bundle, but in fact, page 80. I've already made some reference to paragraphs 75 and 76 at the beginning of my submissions, slightly earlier.
Yes.
On page 18 is the judge's assessment of the mother at paragraph 78, and you'll recall, and I've referred to this, this is where the judge makes reference to many of the criticisms that are now levelled against the judge's analysis on behalf of the father. And at paragraph 79, he deals with the father's evidence. She deals, forgive me, with the father's evidence. The reference at the beginning of that paragraph to the father making reference to mistakes that he had made is to the father's statement of evidence, which is in the supplemental bundle at C128, electronic page 210, paragraph 61, where the father accepts there that he has made mistakes. He says, who doesn't? That says he's never lied to the mother, called or referred to her by names.
Sorry, hold on. Which page? C128?
C128, electronic page 210.
Which paragraph?
Sorry, I just moved away from it. 61.
Thank you. Right.
And just for completeness, I asked the father questions about that, which are on the transcript within the core bundle at page 223.
Sorry, I missed the page again.
223.
Thank you.
And particularly at B and C, and then again at E and F. And the point we would submit that the judge is picking up on there is that despite it being the father's evidence that he had, in the context of answering the mother's allegations against him, made mistakes, when pressed as to what he was accepting having done, he offered really nothing. The judge continues then, back in the judgment 79, to characterise the father's evidence, and this, I think, really specifically relates to his written evidence, of seeking to paint a picture of limited difficulties in the marriage, but that evidence not matching his evidence about what took place on the 24th of November, which the judge describes as not having been an isolated occasion in terms of the parties arguing or the father leaving the car in the way that he did. Now, I'll come on to some of that evidence in a moment, albeit briefly, but effectively in our submission, what the judge concludes at this paragraph is that the father had sought to minimise his part in arguments that took place between the mother and him, that her conclusion that he had minimised and so could not be believed about what happened on the 24th of November suggested that it was more likely that he had behaved in a similar way on other occasions. And that the judge took as support for making the other findings of physical and emotional abuse that she made against the father in accordance with the mother's schedule. And we say that because that, in effect, is what the judge is saying in the second half of paragraph 79, that the father's conduct, as she found it to be on that occasion, made it more likely there had been other serious arguments between the parties where the father had been unable to contain his temper and, in her judgment, is likely to have physically assaulted the mother.
So clear finding, you would say, of physical assault.
Yes.
On what, not just one, but multiple occasions.
Yes. So the building block, as it were, is the 24 November incident about which the father had been
inconsistent. Then you say there's a reasonable extrapolation from that.
Yes.
Yeah.
Because it shows if he behaved that way in the challenging circumstance of that argument, that it's likely that he would have done so in the course of arguments on other occasions. And the mother gave specific detail about the arguments on the other occasions, and the father accepted that there were arguments, albeit not to the extent that the mother asserted.
So you say as a matter of methodology, this is an entirely legitimate way for the judge to have proceeded, and there's a technique which a judge can properly use to deal with the difficult kind of case where you have a lot of conflicting evidence in the emotional context, and somehow one has to find a way through it.
Well, my lord, quite. Here there were two people giving very different accounts, but there were matters that were agreed between them, and particularly it was agreed that they had arguments. The father, in his written evidence, particularly in relation to the 24th of November, had sought to play down those arguments to a very considerable extent, and the judge, and I took you to this slightly earlier on, but the judge, when reciting the parties' evidence in relation to the facts, addresses what the father said happened at page 10, paragraph 47 of the core bundle. So it was accepted that there were arguments, and then the father's oral evidence developed upon his written account, we would submit very considerably. And this appears at various places, and to an extent I'm likely to skip through this quite quickly, for which I apologise. But if you begin within the core bundle at 201, there we have the beginning of my questions of the father about the 24th of November, which one can see at D, analysing the father's statement, which is at C216 of the bundle, of the supplemental bundle, at paragraph 79. And the father really, within his first answers, develops his account by accepting, which he had not accepted in his written evidence, that what happened on that day was an argument. He says there, a discussion or an argument. His next answer, yes, there was an argument. And he then accepts that it was about the child's surgery. At the top of the next page, he
Sorry,
says,
can you just tell me
yes.
his statement is at C216? Got it. Thank
Yes.
you. Yeah.
So it is. We have it in the supplemental.
Is it
bundle.
C216 of the supplemental bundle?
It is. So the way the supplemental bundle has been organised, the C references, as it were, are the same. The electronic page is 298. Oh no, I'm terribly sorry. What I just told you is completely wrong. Apologies for that. It is in fact C131.
Thank you.
Electronic page 213.
213.
Yes, I'm very sorry.
Thanks.
So he begins his account at paragraph 79. So he asserts there, he was very upset and agitated mother had spoken to him in a very irritating manner, closed the car door firmly, but never to the extent of breaking it. Paragraph 80 is his confusing denial of there being any involvement of the church. He says he would have readily engaged with the church. Paragraph 81, which the judge makes reference to him saying that he treated her parents as if they were his own mother and father.
Right, so you're taking us to 201.
Yes, so 201. At the top of the page on 202, close the car door firmly but not violently, so consistent there with his written evidence, but later he gives a different answer. He then goes on to say, inconsistently with his oral evidence, that he had in fact suggested that the parents used the church to try and resolve their dispute. About halfway down the page, between D and E, he asserts he was upset because she wanted to involve her parents, mother's parents, into everything about child surgery and things, and he was upset about that. And then says it's not a normal thing for the parents to interfere in everything in your life. And then the next answer, the problem is her father, my father-in-law, that mother's father treats me in a bad way. And there are other answers as his evidence develops where he raises issue in relation to the treatment that he experienced, he says, from the mother's father. To skip slightly on at 205, at this point asking the father about the mother and child's departure from the home, the father asserts that the mother was staying with her parents, and this is between D and E, because the mother's mother was going to undergo cancer surgery. But in fact, the mother's mother was not diagnosed with cancer until January of 2022. So his answer there can't have been right. And the judge picks up that fact and refers to it within the judgment. And he then goes on to give some answers about his perception that his and the mother's relationship had not ended by that point in time. To move forward a little within it, at 227, beginning at line E of the transcript, the father gives some further evidence about this. By this point, and this is broadly at F, he's accepting that inside the car was a very heated argument.
Sorry, where was that?
227,
yes, I see, got it.
line
Thank
F.
you.
At G, he denies having hit the mother, accepts that he asked her to stop the car, opened the door, and I slammed the door really, really hard. So a further development in relation to his account of his actions on that day. At the bottom of 228, between G and H, he effectively denies there having been angry, but says that he was upset. So, Lords and Lady, there was, we submit, a considerable development of the father's account in relation to what really, in terms of, as I put it slightly earlier on, the dynamic of the relationship of these two parents, their relationship with each other, and the father's relationship with the child, the key precipitating event, because it's what led to the mother leaving the home. And the father has minimised in relation to that in his written evidence, as the judge found and considered, his account has developed relatively considerably in his oral evidence, and that is the foundation for paragraph 79 of the judgment at page 18 of the core bundle. And then the judge goes on at paragraph 80 to address further aspects of this. So having analysed the parents' evidence about the November incident, the judge accepts that the mother and child left to go to the mother's parents' home in October due to an argument, returning 2 days later. That she left on 25 November 2021 and didn't return home. And then deals significantly, we say, at the top of 19, with the aspects of the father's evidence that I've just described and what that means in terms of her assessment of what's happened between these two parents. So she considers that his evidence underplays the extent of arguments and his tendency to lose his temper, that events like that happened more frequently than he was prepared to acknowledge, and that it was as a consequence more likely than not that the mother left due to his verbal and physically abusive behaviour towards her, as set out in the schedule, save with the amendment to A in the schedule. And then she goes on to make the distinction between those events where she's preferred the mother's account of the father's to the other allegations that the mother has made against him, as she details in that paragraph, where she finds them not to have been proved. So she's made a clear distinction, as I said in the beginning of my submissions, between certain categories of allegations and others, on the basis of her assessment of the evidence, which we submit is supported by the oral evidence when compared with the written evidence in relation to the November incident. And if you've reached a finding, we would submit as a general proposition that in the course of one argument that a person has sought to minimise in the way that the judge found that the father had, that he had behaved violently and aggressively in the presence of the child, it is certainly possible and permissible and rational and justifiable to consider that in other contexts where arguments have arisen, the same person would behave in the same way. And that is why the judge found herself able to find not just the 24 November incident, but the wider incidents that fall within the same heading or category, but which show the same sort of behaviour from the father in similar sorts of contexts. In relation to the child's part of it, the judge deals with that at paragraph 81, considers it more likely than not that the child witnessed either directly or indirectly the arguments in a way which on any view she found was deeply damaging to his emotional welfare. And that's not a stretch. Of course, we know that children are victims of domestic abuse where it occurs within the household within which they live, and that it is damaging for them. Can I come on then to address some of the specific criticisms made of the findings as set out in the order, if now's a convenient... I was going to say if now's a convenient time to do so, but if I don't do it now, it's probably not going to happen.
Yes, please.
So, Lords, my lady, within the taking them from the schedule to the order.
Yes.
So, Core Bundle 27A, the allegation, as the mother put it in the schedule, that the father hit her in her pregnant belly, amended by the judge in the paragraph that we've just looked at, to the mother thinking that the father was going to hit her there. Well, the judge deals in the judgment at Core Bundle page 9, paragraph 42, with how the mother had put that in her first statement. I thought he was almost going to kick me in the stomach, but I ran into the kitchen. within her asylum interview, as was raised with you, I think, by Miss Guhar, and this is in the supplemental bundle at E22, electronic page 417, the mother's evidence was that she thought he was going to hit her in the abdomen at a time when she was pregnant. So if there's a discrepancy here, it is between how she put it in the schedule as compared with how she had said it in her evidence or in the asylum interview.
Do you happen to have the reference for her statement?
Yes. The statement, I think, is at C8, electronic page 90.
And paragraph
14.
1.4.
1.4.
And sorry, can you remind me, was this then amended in the second statement?
No.
Right. And then the asylum interview is E22.
E22, electronic page 417 of the supplemental bundle.
And the oral evidence?
This may be my failing, but I have not been able to find where this was dealt with in the oral evidence. Oh, there we are. Miss Guhar tells me it's 192F.
Thank you. You refer to that as my notes, not
Electronic page 8.
could be. Yes, that's it. He did attempt to hit me. Right.
Yes. So there's a degree of consistency, and it may be that there is a distinction between kick and hit. But in our submission, that's something that in the wider context of this case, with all of the difficulties faced in the mother's evidence, is explainable and understandable. But the distinction as between thought he was going to and did is one that arises between the drafting and the schedule and the evidence.
Yes.
In relation to B, the tried to hit and broke his fingers on the door. The mother's oral evidence is within the same document, 192F and 192G, bottom and top of the page respectively. She asserts there, father was so angry he tried to hit me in the face but instead hit the door and broke his finger. The asylum interview, E24 419, in the electronic bundle. Mother says he would knock on the door really hard, that he broke his finger. And the schedule tried to hit me in the face, but instead hit the door and broke his finger. Again, in our submission, it's not so significant, the distinction in terms of the mother's accounts, which all involve an element of the father hitting a door, as to render it irrational or unsupportable. The judge made a finding in that particular regard.
And the statement, I've got my note, is C9, paragraph 23. So angry he tried to hit me in the face, but said hit the door and broke his finger.
Yes.
Yeah.
So again, and this is a broad submission that we make in relation to these, but there is a thread of consistency that runs between them. There may be slight differences of account, but in circumstances where the judge has made the finding about the father's temper and reaction to arguments, she was entitled in that context to choose the mother's account, differences between them as there were, but explainable ones over his.
Sorry, made findings about the father's temper and, do you say reaction to arguments?
something along those lines.
Yes.
I can't remember, I'm afraid. The
No, it's all right.
specific
I
word
remember that
used.
very well, not being able to repeat submissions that I've made. Yes.
But it always feels so awkward when one's put on the spot.
Mm-hmm.
But it was along those lines, certainly.
Yeah, thank you. So that B.
So that's B. In relation to C,
Yes.
this is the allegation of spitting in October 2021. Starting, if I may, with the mother's oral evidence in this regard, and the core bundle at 185 going over onto 186.
Hold on.
I'm terribly sorry.
Yes.
So 185 at the bottom of the page over to 186. The criticism effectively here is that the mother began to recount one thing, that he was slapped, and then her evidence changes to say that he spat at the mother. And it's asserted that whilst the mother had recounted other aspects of this in her statement, which I suspect is very close to where my lord was just looking. C11, paragraph 29.
Yes.
She had not mentioned the spitting.
Well, it was that one morning in early October 21, father woke up angrily, shouted at both of us, and started to hit and kick the child.
Yes. But the judge has rejected that account as not forming an aspect of the father's character. My lord, it must be possible for a judge to accept parts of one account and not others. Otherwise, one would find oneself in a situation where, having rejected one part of a person's evidence, you had to reject the whole of it. And that would be entirely wrong.
I think what was being suggested is that there's no reference to slapping. Is this dealt with in the asylum interview?
I did just. Yes. So E23, electronic page 418. At the bottom of that page, I think, is the relevant part for this purpose. And actually in two places. So probably about halfway down the page, there's a part that begins, even in front of his friends, he would tell me not to talk.
Sorry, I haven't got that yet. Yes, got that, thank you.
And the mother goes on to say he slapped her and pulled her hair, spat on her, was hitting the kid as well as slapped him. And then at the bottom of, or towards the bottom of the page,
Then the one time.
I'm terribly sorry, I spoke over you.
No, I was thinking we were referring to then the one time. Is that it?
No, there's very spat at me 5 lines before the bottom.
Yes.
Yeah.
So there's a part where he says he told my son he is sick of him and makes him tired and he's very clingy and
Yes.
crying all the time.
Yes.
And then he spat at me.
Yes.
So this is and was an aspect of the mother's account at different parts in these proceedings. In the asylum interview, she details it. In her oral evidence, she does. Where she doesn't is in the statement that is plagued by the difficulties in terms of how it was prepared, with the involvement of her brother-in-law and what that might have meant for it. So again, we would submit that the judge was entitled to accept that as having been something that happened on the basis of the mother's evidence that it did, bearing in mind her view generally of the father and his conduct towards the mother.
And is it part of your submissions that we shouldn't get over mesmerised by minor inconsistencies between things the mother has said in different contexts?
Yes.
In her witness statement, A, before amendment, B, after amendment, C, in cross-examination, D, in interviews in relation to her asylum appeal, provided we're satisfied that the judge was at a higher level correct in her diagnosis of the way in which the father was prone to behave when provoked. And
yes, it certainly is. On any view, these are examples, whether within the statement or the asylum interview, of the mother recounting things that happened a number of years before. The asylum interview was, I think, 22nd of April 2024, and she's talking about, in different contexts, things that happened in 2018, 2020, 2021. And the statement's the same, plagued with the difficulties that they were. It is also, to an extent, with no disrespect to the submission made, an example of the island hopping that I mentioned at the beginning of my submission, going between different parts of accounts to try and demonstrate inconsistency between them in circumstances where all of this was put before the judge. The judge did the job, we submit, of identifying the issues that were raised with the mother's case, but also the father's case as well, and reached a conclusion in relation to specific categories of fact on the basis of her analysis of that evidence.
Yes.
Lords, my lady, that goes slightly over my time, but deals certainly in headline with the submissions that we wish to make, taken alongside the skeleton argument.
In respect of the other specific, you dealt with E.
Well, E we've accepted.
Should be deleted.
Yes.
Insofar as the other ones are concerned, essentially you make the same submission. There was, insofar as there were inconsistencies in the mother's account in different aspects of her evidence, the judge would have been aware of those and wasn't required specifically to address them.
Yes. And to take the specific ones almost probably at more than a canter, D, the judge addresses in detail in any event.
Yes.
F, the judge having found that the child was present during the course of what, if her finding stands, would have been a very upsetting and distressing argument.
When was that? What? That was the... Yes, okay.
So F is specific to the 24 November.
Yes, yes.
It is certainly possible that a child would react to witnessing events of that nature in the way that the judge found. G, verbal abuse, and it is right to say that that did not form a large part of the oral evidence. It was certainly put to the father at the least that he called the mother dumb, but these are aspects of the arguments that the mother said occurred, and the judge would have been entitled to make findings in relation to those. And, my lord, as I relying upon your summary of our case in that regard, the same is true of the others. If the father was behaving in the way that the judge found towards the mother, the judge was certainly more than entitled to find that the father had used verbally abusive language towards her in the way that those findings suggest. K relates, of course, to the mother's account of why that argument was taking place at all, which was her suggestion, which is dealt with within that finding, that the father had threatened to cancel the operation.
Is the finding that the father did not care about the child's health based simply on that one incident?
For one moment.
mean, it is in the schedule.
Yes. I'm just checking the evidence, forgive me. So, my lord, it is that the mother also, you'll have to forgive me while I find it, because I'm working now from my notes for the fact-finding hearing, but at paragraph 27 of one of the mother's statements, let me just find which one it was. Yes, C10, electronic page 92 in the supplemental bundle.
Sorry, which paragraph?
Paragraph 27. The mother makes a general assertion in relation to the father's attitude, but that is the background of the evidence. I think it's probably fair to say that when the judge includes that on the basis of the schedule, it relates to the operation incident, probably rather than those things.
So it might, yes, it would be sensible to make that clear. Yes. No, thank you very much.
Thank you.
Yes, thank you for your written submissions, which have explained clearly the Guardian's position.
Yes, my lords, my lady, the Guardian does not seek to support or oppose the appeal.
Yes.
And does not feel able to comment on the matters that are traversed in this appeal, and she feels it's a matter for the court and not for her to make comment on those arguments.
And I haven't gone through all the transcripts in detail. Did the Guardian, were questions asked of the parties on behalf of the Guardian in respect of the matters that they were each advancing?
Questions were asked on behalf of the Guardian. They were, I think they were largely addressed by the parents' advocates, and there were some questions put by Mr. Powell on behalf of the Guardian in relation to some matters. I think they were, if I may turn it up, I think they were largely about the father's acceptance or otherwise of the mistakes he had made. I think Mr. Powell asked questions in relation to that.
Okay. Thank you. And we've had reference to the submissions that were made on behalf of the Guardian, and we have a copy of those in the bundle.
Yes.
Thank you. Is there anything else?
Nothing further than to assist the court. I should say that the Guardian does wish to file and serve an addendum to her report.
Okay.
And she would like to do that once the outcome of the appeal is known.
Yes.
Really dealing with the parents' reactions to the findings that the court has made, and dealing with an update in relation to A's welfare.
Okay. Thank you very much. Thank you. Yes, Ms. Guha.
Well, just a few points in reply. Firstly, the court has been taken to the opportunity that the mother took to amend key aspects of her narrative in respect of her allegations of abuse. It's important to record that the schedule of findings was in fact signed by the mother. This is not simply pleading prepared by lawyers, but that was entirely divorced from the lay client. She was taken through it with an interpreter, and she signed it at the end of that document. So that stands as a piece of the mother's evidence. Just also make the obvious point that the findings being sought by the mother were extremely serious in respect of the father perpetrating domestic violence. So when the submissions are made that there was a thread of consistency, that these are minor issues of detail that the judge was not obliged to deal with, I hope what we've demonstrated during the course of this appeal is that with every finding, the fundamental evidence on both sides is not addressed in terms of the judge's analysis as to whether she accepted that account, did not consider the differences in the mother's various accounts to be material and why that was. And despite the other findings of that the mother had not told the truth, that in this instance the court could be satisfied that what was written in the schedule should be adopted as the one of many, as the true version of one of many different accounts. And this all very much, of course, ties into the challenge mounted on the basis of adequacy of reasons, because in reading this judgment and this analysis, how is the father and any other reader to understand why the mother adopted the version that was alighted upon in the Scotch schedule rather than the statement or the asylum interview? Where is the father's evidence, for example, in respect of how he fractured his fingers? How was that factored into the analysis? Why was his evidence rejected? None of that rationale is apparent from the judgment, and that is why we say it is not rationally supportive. This is not island hopping. Again, we've been able to go through each and every single finding to show how there were fundamental discrepancies which were not addressed in the judgment. We say the aspects of the father's credibility which caused concerns, by contrast, were peripheral aspects which did not justify the schedule of allegations being accepted in its entirety. The judge evidently took a very broad brush approach to the granular detail of these allegations. And finally, it's been submitted today that finding E can be disregarded and excised from the order. The difficulty with that is that it was half of the jigsaw in respect of the mother's narrative as to what happened during the key incident on the 24th of November. And if E is excised, then that...
Well, I think E is, it's accepted that E should be excised on the basis that the judge did not make that finding.
Well, my Lord, the difficulty...
Not that there wasn't evidence necessarily to that effect, but the judge just didn't... The judge said, I'm finding, apart from the adjustments, amendments we talked about, 3 and 4, but this doesn't feature in 3 and 4.
Well, my Lord, the difficulty is in looking at the analysis and how the court is being invited to approach the analysis and reasoning in the judgment, and not simply looking at what follows from paragraph 75, but to look at the totality of the judgment. Paragraph 79 cannot be reconciled with paragraph 46, because at paragraph 79, it simply ends with the finding, the very generic broad brush finding, that it's likely that the father physically assaulted the mother in the way that she has described. That must be cross-referred back to paragraph 46, in which the evidence recorded by the court is the account, including what happened at the home after the parties left the police office, including the controversial aspect of the mother's evidence, which was whether she was dragged by the hair, slapped by the face, and hit everywhere. And I would submit that this exemplifies the deficiencies in the reasoning and the analysis, because that is not the solution, simply excising finding E, because then one does not have any clarity as to what happened during the key incident of the 24th. We only have the incident of the car dealt with, nothing thereafter, and how can finding F stand if E goes? Because finding F is directly linked to what happened, what is said to have happened at the home. And because one will recall, A, there was a dispute between the parties whether Jason was present in the car, but the totality of the mother's allegation is that she was punched on the shoulder or on the back or slapped with an open hand in the car. The allegations she in fact made as to what happened in the home were far more serious. And we would say, therefore, this issue in of itself, not only in respect of the detail of the key finding as to what happened on the 24th of November, is fundamental in looking at whether these findings can be sustainable, but it also permeates through all these findings in respect of emotional physical abuse, because we wholly agree with the submissions that the judge used the incident of November as a launch pad, to make all the other findings of emotional physical abuse. And for those reasons, we say that those findings must be set aside.
Thank you very much. Thank you for your respective submissions. We will reserve our judgments. They'll be provided to you in draft in the usual way for typographical errors, and obviously, as you will know, not to seek to re-argue, and further not to be used for anything other than the limited purposes for which they're provided. And it has the warning at the top, which I think I'm supposed to refer. We're obviously aware of the relative urgency. We've drawn attention to the fact that the asylum appeal is not going to happen until July. So we will endeavour to deliver our judgments as soon as we can. And finally, once you've got the judgments, I would expect you'll be able to deal with outstanding matters on paper. Expect to deal with outstanding matters, but if there are any issues, we will deal with them on paper. Thank you.